Good evening, and a very warm welcome to Bentham House, home of the Faculty of Laws at University College London. We've come together in person and online to celebrate the inauguration of Professor David Ormerod. I'm Professor Stephen Vaughan, one of the Vice Deans in the faculty, and your host for this evening. As host, I have two tasks. The first is to introduce the chair for this evening, who in turn will introduce David. The second task after the lecture has finished is to inaugurate David on behalf of the Provost. Inaugural lectures are very happy occasions, a rite of passage, a chance to come together in public and with pride to celebrate the achievements of one of our own. Tradition at UCL is that there is no Q&A after the lecture, which, given David tells me the topic for tonight is somewhat controversial in some circles, is perhaps no bad thing. So let me introduce now Sir Andrew Edis, the evening's chair. The Right Honourable Lord Justice Edis is the senior presiding judge in England and Wales. As a Scouser myself, and I say this, and I simply note that David is from Manchester and I'm not going to cast any aspersions. As a Scouser, I was pleased to hear that Sir Andrew is also from Liverpool and studied at Liverpool College, from there to Univ at Oxford and to the bar in 1980. Sir Andrew became an assistant recorder in 1994, was made Queen's Counsel in 1997, a Deputy High Court judge in 2001, a bencher of Middle Temple in 2004, and was Senior Treasury Counsel at the Central Criminal Court from 2008 to 2014. At the criminal bar, Sir Andrew's work included many high-profile cases, such as successfully defending footballer Bruce Grobbelaar on a charge of match-fixing, prosecuting the former Secretary of State, Chris Huhne MP, and his former wife, Vicky Price, for perverting the course of justice, and acting as lead prosecutor in the News of the World newspaper phone hacking scandal trial. A piece in the Financial Times reports that Sir Andrew's colleagues comment that he is, quote, never anything other than cool, calm, and collected, even in the teeth of serious provocation. Following a knighthood and appointment as a Justice of the High Court in October 2014, Sir Andrew was appointed to the Court of Appeal in January 2021. Now, Sir Andrew will, I'm sure, speak to David's many exceptional achievements as a legal scholar, as a law commissioner, and as a judge. Before he does that, let me just say that as a colleague at UCL, I can give David no higher accolade to say that he is a good citizen. He is kind and caring towards academic colleagues and professional services colleagues. He's devoted to his students. He is giving of himself. And when I was head of department, I knew that whatever the ask, I could email David and say, would you mind? And he would always reply to say, I should be happy to. David, we're very pleased you're a part of our UCL Laws community, and I'm incredibly pleased to be part of this inaugural lecture tonight. So Andrew, over to you.
Well, that was very kind, but I need to offer a factual correction. I did play a part in the acquittal of Bruce Grobbelaar in 1997 on match-fixing charges, but the person who actually did the job was Professor David Ormerod's father-in-law, the late lamented Rodney Cleven, who was my leader and who did the case with his customary elan and brilliance. It's a small world, isn't it? That was 1997. I don't suppose we would have imagined, had we been thinking about the future, that we might end up here in doing this. This is rather a collector's item, even to a connoisseur of backlogs and delay, such as myself. Professor David Ormerod was appointed to his chair here in 2015, and this is his inaugural lecture. It's not just delay of the culpable kind, not at all. Of course, as you'll all know, he spent some of those years still fulfilling his important role at the Law Commission, not able to come and take up his position here. And then the pandemic took over, and we know what that did to backlogs everywhere. He left the Law Commission in January 2020, just at the moment that the virus was sweeping the world, an unrelated event, of course. He is now the director of the Centre for Criminal Law and co-director of the Judicial Institute. He holds a number of positions in addition to his chair here at University College London. This may be why the audience for this inaugural lecture contains such a diverse group of people. I can see from my world many, many familiar faces who've come here, and there are also academics, students, and others interested in this area of the law and the subject matter of this evening's lecture. He remains an honorary professor at Queen Mary University of London, where he taught for a number of years before he was appointed here. Before that, he held chairs at the Universities of Leeds and Hull, having begun his academic career at the University of Nottingham, alongside the late, great giant of the criminal law, Professor J.C. Smith, whom many of us remember well. All of you will know of his academic writing. In addition to the scores of journal articles and book chapters, academics and students will be most familiar with his work on Smith and Hogan's criminal law, which he has authored on his own for a number of editions and now co-authors with colleagues. He has been the editor of the Criminal Law Review for many years, also having previously before that contributed innumerable review articles and so on to make that publication what it is. So those are the two great staples for practitioners of an academic bent, I suppose, where they will find current, accurate learning from the academic sphere to support our work in the criminal court. So there's an interface there of great importance to us. He, of course, is also widely cited and relied upon by academics as well as practitioners. His work is influential in the academic sphere and in the law courts. If you read the decisions of the higher courts in criminal cases over the last couple of decades, you will find a number of references to him, and I don't think you'll find one where the court says that Professor Ormerod was wrong. I may be wrong about that, but I can't just think of one. Those who are deep in the ways of the criminal law, who have lived with the decision of the House of Lords in Psych about conspiracy and other related interesting matters, may remember that Lord Nichols, in his speech in that decision, acknowledged the helpful insights that the court had obtained from Professor Ormerod, which is quite a distinguished thing to happen. He was then the Criminal Law Commissioner at the Law Commission between 2010 and 2020, steering some of the most important reforms in the criminal law through the system, involving work with parliamentary draftsmen, involving work with select committees, and appearances in the House of Commons, as well as on the media, quite a high-profile role. Probably, when we're all forgotten, the Sentencing Act 2020 will not be. That, at any rate, is our profound hope, those of us who understand where it came from and what it's for. It's supposed to pull it all together so that when they change it, they change the 2020 Act and they don't introduce another one. That's what it's for, and therefore we hope that it will still be around, as I say, when we are long gone. He holds a doctorate of civil law at Northumbria University, in addition to many other distinguished degrees, which I will probably fail to mention some of because time moves on. He has been also the editor of Blackstone's criminal practice, alongside, I think, David Perry, who's in the audience here today, and have, between them really, created that work as another, I was not going to say a second, another standard work for the use in the criminal courts by criminal practitioners, placing the whole complicated canon of criminal law in a single volume so that it's all there and accessible. From the point of view of the practitioners, the merits of the two books sometimes can be assessed by working out which has the best index, which is the one that allows you to get there quickest. I think it may be, although I think we have editors of the rival publication here as well, that it may be that whatever the merits of the rival publication, that the Blackstone's index is just a little bit better. But that's enough of that. He is a bencher of Middle Temple. He was reader there at the Inn in 2022, and he's been involved in educational work at the Middle Temple for many years. He also has a similar involvement with the Inns of Court in Northern Ireland. We judges here, who are, I think, all criminal judges, or most of us here are from a criminal background, all of us, I think, probably here now practicing criminal law in part, owe him personally an enormous debt, because he has been involved for many years in a critical role training judges through the Judicial College, formerly the Judicial Studies Board. Certain key elements of the curriculum in that institution were more or less invented by David, and his indefatigable work keeping all of that up to date, his enthusiasm for making sure that the training that's offered to judges is of the highest possible quality, has made a serious contribution to the quality of justice in this country. In fact, the work of the Court of Appeal Criminal Division is rather down on what it has been historically just at the moment. I wonder if there are fewer appeals against conviction now because all the judges have been trained by David, so they don't get things wrong in the way that they perhaps used to. In 2013, he became an honorary Silk, then QC, now KC. 2018, he was appointed as a Deputy High Court Judge. And in 2021, he was appointed CPE in recognition of his services to criminal justice. No award could possibly have been better earned. I'm delighted to be able to introduce this lecture. One sometimes reads, when one opens a periodical, that the publishers of the articles owe no loyalty or are not responsible for the content of those articles which are published. It is a controversial subject. I'm delighted to introduce it, but I'm expressing no opinion of my own by doing so. Thank you.
Thank you very much indeed. Those words mean so much, not least because they come from a person who, for me, is simply the best criminal judge in the country. Well, this is an interesting topic, isn't it? On a wet Wednesday last November, it seemed like a good idea to have a bit of a poke at the High Court. But now, looking at you all across the room, perhaps not such a great idea. Can I say, by way of introduction, two matters. First of all, there is a question mark at the end of the title. This is a lecture designed to provoke debate. Secondly, as I recognise in the audience so many of the High Court and indeed the Court of Appeal from non-criminal backgrounds for whom I have enormous respect, let me reassure everybody, lest there be any doubt, that nothing in the lecture is prompted by any case or any judge. This is no question mark on my part as to the extraordinary ability of the King's Bench judges. In the lecture, I propose to argue first that judging criminal cases is distinctive, both at first instance and on appeal, and that it demands a cadre of expert and experienced judges. Secondly, I examine what is expected of the King's Bench judges in the criminal law and ask whether the current system of recruitment guarantees the level of expertise and experience to equip them adequately in the performance of those roles. And finally, I assess a range of options for reform, including, most radically, the creation of a new criminal division of the High Court. Underpinning the entire lecture is a desire to debunk a myth. Some people assume that crime is easy, not the commission of it, but the study, the practice, and the judging of it. And I believe that assumption has had systemic impacts on the appointment and deployment of High Court judges, and indeed on the structure of the High Court. There is, in my view, no obvious reason to assume that judging criminal cases is any easier than judging disputes in any other branch of law. It requires the same skills of statutory interpretation. Indeed, the argument could be made that it's more demanding in that regard. Witness the 19 pieces of primary legislation on sentencing in the last 30 years. Criminal trials also give rise to their fair share of constitutional issues and Human Rights Act challenges, as demonstrated recently by the debacle following the decision of the Supreme Court in DPP and Ziegler. It seems clear to me that judging crime is no easier than any other branch of law, but I don't need to go on to demonstrate that. For my purposes, it's sufficient that I can demonstrate distinctiveness. So what is the distinctive nature of criminal trial and appellate work? I spend a lot of time with Crown Court judges. I teach with them every month. Judges are candid with me. One very experienced circuit judge recently confided in me that trying a criminal case is often like driving a heavy goods vehicle with no brakes and dodgy steering, hoping to come to a stop somewhere safely. And behind that humour, there is a more serious point. The distinctiveness of judgecraft in the Crown Court trials is illustrated by several features. First, the nature of the dispute. Of course, any dispute that's got as far as a trial is going to affect people's lives, but probably no other area of law has the same significance with such routine intensity as crime. There's a unique stigma attached to being on trial, let alone convicted. Lives are changed fundamentally. Secondly, consider the role. Crown Court judges should shoulder ever more onerous responsibility in case managing trials, including handling participants, many of whom are vulnerable, including defendants and complainants, and in contrast with civil cases, there are few professional witnesses. But the most distinctive feature of the process is the responsibility that the ultimate decision is shared with 12 strangers, possessed of no legal training, conscripted for the task. The judge must secure each juror's collaboration, foster their collegial spirit, chaperone them through the evidence, and then deftly guide them to reach a fair verdict. And the presence of the jury has ramifications on the criminal judge's role in many ways. The judge must possess exceptional foresight, having continually to anticipate the impacts that a ruling on admissibility will have on the jury and how to craft directions. Decision-making on mid-trial applications needs to be swift to avoid the proceedings becoming even less comprehensible and even more disjointed and inconvenient for jurors. Indeed, planning and timetabling the entire trial will be driven by a desire to accommodate the jury. The judge must safeguard the jury from hearing what they ought not and avoid any unguarded comment. The jury's presence leaves less margin for error. Slips may well lead to an application for the jury being discharged. And furthermore, the judge's communication throughout must be so effective as to secure in everyone, the defendant, the complainant, the public, a confidence that the jury have followed the evidence and that they have understood and can apply multiple complex legal directions. Even with the Crown Court compendium to hand, bespoke directions are demanding. Turning to appellate criminal judgecraft, common sense suggests that any appellate judge's role is made easier by an ability born of experience to understand the first instance judge's decisions. But criminal appeals, I would argue, are distinctive. I suggest that because they require more from the appellate judge by way of reconstruction of the trial process. The appellate criminal judge therefore relies more heavily on prior criminal trial experience. The pace and unpredictability of the criminal trial, reliant as it is on so many lay witnesses recounting emotive events, makes it unrealistic for there to be carefully crafted rulings on matters of law. Trial rulings are extemporary, they're short, they're underdeveloped, and moreover, there is never a reasoned judgment on the ultimate issue, as there would be in every civil appeal. To understand the reasoning underpinning the verdict, then, the appellate criminal judge must engage in reconstruction from written directions, the indictment, as is often amended, and a host of other materials to understand how and why the verdict was returned. So criminal judging seems to me to be distinctive. What's more, these distinctive skills involve an expertise that is, I argue, best exhibited by those who've acquired criminal trial and indeed ideally appellate experience. They have subject matter and decision-making expertise. Unsurprisingly, there is a rich psychological literature on what constitutes expertise. And while experience and knowledge are necessary, neither alone is sufficient. Expertise is about how the person identifies and approaches problems, manages uncertainty, and gets things done. And over decades, many empirical researchers, chief among them perhaps Gary Klein, have confirmed that decision makers typically demonstrate their expertise by recognizing problems as situations they have experienced. And that is what allows them to make decisions comprehensively, with finality, consistency, as well as with greater self-reliance. Now, this is a contested point in psychology, and not surprisingly even more so when you try to transpose that over to law and judging. And of course, I acknowledge that judges receive judicial training. More of that later. Let's now consider the role of the King's Bench judge. And the High Court there we can see represented diagrammatically. 3 divisions of the High Court. Worth noting that there is a separate family division, but its origins are rather by default than design. That jurisdiction was effectively orphaned by the Chancery Division in 1971. I'm interested in the King's Bench Division, and within that you will see the specialist subdivisions. Curiously, nowhere is there mention of the criminal law, but crime is one of the many disciplines in which the King's Bench judge will sit. Looking at the diversity of the subject matter there, I'm sure I'm not the first person to view the King's Bench judge as the judicial equivalent of the Swiss Army knife, required to perform so many functions, no matter how unusual, but with expectations of doing everything with precision. We'll probably all have our own views, and I can see people thinking now, which sub-jurisdiction is so obscure to be the equivalent of that tool that takes the thing out of horses' hooves? It's admiralty. So far as criminal work is concerned, the new King's Bench judge will, after some limited training, be required to try murder cases and thereafter probably little else except high-profile crime and some terrorism. They'll be expected also to make decisions on whether to grant permission to appeal conviction or sentence from the Crown Court. Those are the 2 roles I wish to focus on. And the judge acts alone in both of those roles, both of those capacities, involving first instance and appellate decision-making, reflecting the hybrid nature of the King's Bench judge's work. Before we examine the roles, it's worth noting the level of experience in crime which the judges appointed to the King's Bench might possess. A very small number have no criminal experience whatsoever, either in practice or as a judge. There's no prerequisite for any criminal experience. Some will have experience of practicing crime, but none in sitting. Most commonly, however, the judge will have been a recorder in the Crown Court, sitting part-time a few weeks of the year. They will therefore have developed some of those judicial skills, distinctive skills that I noted, but they will not have tried a murder nor an attempted murder, nor will they necessarily have tried even very serious crimes such as sexual offences or long cases, nor will they have sat in the Court of Appeal Criminal Division. On appointment then, most are not expert criminal lawyers and are not expert judges either, having only ever sat part-time. They received training, but that is a meagre few days a year or so. Whatever their expertise as a lawyer or experience as a judge, a King's Bench judge will invariably try a murder as their first criminal trial in that role. And for those with limited experience, that prompts me to question whether it's fair to them, let alone participants. To assess the appointment process, whether it ensures that all King's Bench judges are well equipped, we must explore what the roles of the King's Bench judge in crime entail. Trying murders. Well, it's trite to say that murder is unique in stigma and sentence. For any judge other than a King's Bench judge, the opportunity to apply for authorisation or a ticket to try a murder arises only after years of experience sitting on criminal cases full-time. Expressions of interest typically require 5 years' experience as a full-time circuit judge. Trying crime is demanding. In terms of substantive law, the offence necessarily engages complex issues of causation, which never seem to find a firm foundation in the criminal law. even the Supreme Court acknowledging that there was no single set of principles. Murder is unique in providing partial defences, loss of control, obscure in drafting and requiring that onerous judicial gatekeeping role, diminished responsibility, bringing predictable handling difficulties with a potent mix of mental illness expert witnesses, reverse burdens. Evidentially, murder trials routinely generate some of the most contentious applications of the bad character regime, gang affiliation, drill and rap music, and skillful handling is required to avoid risks of prejudice. Other complex technical evidential issues are commonplace: DNA, ballistics, forensic anthropology, and so on. Procedurally, many murders will involve handling frightened or hostile witnesses. Many trials are multi-handed, generating more acute evidential and procedural issues, even if the Supreme Court decision in Joji has exercised the spectre of joint enterprise, which I doubt. And as any murder-ticketed judge will tell you, lurking at the end of the evidence is the knotty procedural quandary of when and how to leave manslaughter to the jury as an alternative verdict. As for sentencing, although fixed by law, the judge's task is far from straightforward. And of course, in all of these cases of such high stakes, some of the very best advocates will appear and quite professionally rely on their years of expertise and guile. All in all, trying murders is difficult. Unsurprisingly so. We currently place the burden on only the most experienced circuit judges, but we're willing to do so on any King's Bench judge, whatever their background. Let me turn to the second principal role performed by the King's Bench judge that I want to focus on, that is in filtering appeals. Now, to be clear, my challenge here is not to the role of the High Court judge sitting in the full court of the Court of Appeal Criminal Division. In that situation, the judge is but one member of a panel hearing an appeal, participating in the delivery of a unanimous judgment, reasoned after oral argument. Any lack of expertise of the single judge will then be compensated for by the experience of the other members of that court. As an aside, it's just interesting to note, isn't it, that the typical constitution of the Court of Appeal Criminal Division may be an illustration of the way that the assumption that crime is easy has taken hold. Why do we have only one Lord or Lady Justice of Appeal in a criminal appeal, but 3 in every civil appeal? Is it because we think those cases are more difficult or matter more? To reiterate, my focus is not on the full court, but on the role of the single judge in filtering appeals. Now, to set that in context, contrary to lay perceptions, there's no right to appeal from the Crown Court. There is merely a right to seek leave to appeal. There's a filtering system under Section 31 of the Criminal Appeal Act, and the High Court judge plays the leading role in that function. The significance of the filtering system cannot be underestimated. Without it, the Court of Appeal would drown in work. In 1999, in the case of Cox and Thomas, Lord Bingham, the Lord Chief Justice, emphasised that the process was the linchpin of our appellate system in the field of criminal justice. So what is the High Court judge's role? Well, the judge decides whether to grant leave, to refuse leave to appeal, or to refer the whole application to the full court. If the judge refuses leave, then the applicant can, as an important safeguard, always renew to the full court. The judge can also initial the loss of time box on the application form, indicating that the application is wholly without merit. And if the defence then choose to renew the application to the full court, there is, to use the language of Lady Justice Hallett, an expectation that if the full court also refuses leave, then the applicant will serve part of their prison sentence again. So the significance of this decision is enormous. Looking at this in terms of the figures, taking 2019, which is a very convenient year for statistical purpose, as it's untainted by pandemics and industrial action and so on. There were, as you can see there, 4,227 applications for appeal against conviction or sentence, of which 3,321 were refused by the single judge. No arguable case was the decision of the judge. 917 of those renewed their application to the full court, and in 94 of those, the Court of Appeal granted leave, effectively concluding that there was, in fact, an arguable case. And then in 58 of those, the ultimate appeal was allowed. So what's my concern with Section 31. My concern is that the High Court judge, who may well have limited criminal trial experience and even less appellate experience, sitting alone, working solely on the papers, no oral argument, traditionally outside normal court hours, is expected to determine applications which may relate to serious and complex crime. As I say, the appellate decision is made on paper with no expectation of extensive reasons. As another aside, perhaps the use of remote links could prompt debate about whether we should have oral argument in the more complex Section 31 applications. A further difficulty is that the decision is parasitic. The judge's decision involves a prediction on his or her part about how the Court of Appeal might decide the appeal. Unfortunately, the tests the Court of Appeal itself will apply in deciding the appeal are notoriously ambiguous. They are in fact a target for reform. Just what is unsafe? When is a sentence manifestly excessive? So there's a compounding of the difficulty. The filter decision under Section 31 is parasitic on an ambiguous test, and it's being made by someone who may have limited experience of trial work and limited experience of Court of Appeal work. Even if they've sat as a recorder before appointment, they cannot have sat in the Court of Appeal Criminal Division in that role. Just going back to those figures, is my concern supported by evidence? Well, it's very difficult, and I'm not making a very great claim here. The figures from 2019 revealed that in around 10% of the applications that were renewed to the Court of Appeal, the Court of Appeal disagreed with the Section 31 judge and concluded that there was an arguable case. But that figure may well be inflated. Those are probably the strongest cases. They're the ones in which counsel was most invested, or that technical glitches have been noted by the Registrar's Office, albeit missed by the single judge. And of course, they were decided by the full court after oral argument. But nevertheless, it is an indication of the potential for false negatives. And we don't know anything about the other 2,200 cases in which there were no renewals made. So, to recap, I question whether, given the range, complexity and diversity of the decisions that may be required of the single judge, one might expect that considerable experience of criminal trial process would be a prerequisite to fulfil that role. And to articulate that aspiration is not simply to fulfil some academic desire for a pure system. There are important practical consequences flowing from the decisions. There's a real risk that the judge will simply not see the technical or tactical points of law and practice that have arisen. And the risk is exacerbated perhaps by the absence of any oral argument and judicial collaboration. Indeed, considering the adequacy of the current regime of appointment and training for both demanding roles at trial under Section 31, there are numerous risks. These include that the inexperienced High Court judge will be more likely to make errors, be less efficient in their conduct of the trial, need longer to try cases, require education by trial counsel, need more assistance from the judges at the court centre at which they're sitting, require more assistance from the Court of Appeal Office on Section 31 applications, present challenges for the registrar in selecting appropriate cases for their limited experience, and present problems to the president, listing officers and the presiding judge for the circuit as to which types of case they may confidently be permitted to try at first instance. And to articulate something rarely, if ever, spoken, perhaps the King's Bench judge is less confident than they deserve to be in their very high-profile position. I worry that there remains a culture that simply expects excellent lawyers appointed to the High Court bench to get on with it, whatever the subject matter. Now, I'm not suggesting that all King's Bench judges are lacking in criminal expertise. Looking around the room, that's plainly not the case. I'm arguing rather that we should only expect judges to perform those key roles when possessed of appropriate expertise and experience. I recognise that there's an inherent tension in my argument. If I'm demanding expertise based on experience, and judges can only deal with murders when they possess experience of dealing with murders, how would anyone ever start to acquire any experience in the first place? Well, the answer to that has to be viewed in the context of the ticketing system for criminal judges and the appointment regime. The ticketing system allows for circuit judges to develop throughout their career experience of progressively more demanding trials, incrementally enhancing their skills, securing a ticket to try serious sex cases, a ticket to try attempted murder, and finally a ticket to try murder. There is no similar scheme for King's Bench judges in crime. Now, the fact that the High Court judge rarely tries sex ignores the fact that so many judgecraft skills are acquired by the circuit judges in fulfilling those roles. Similarly, in terms of appellate criminal experience, if I'm requiring prior Court of Appeal experience, and yet you can never acquire that before you've been appointed to the High Court, how will I ever fulfil the appointment criteria? But that can be countered, I think, because the requisite experience can be more safely acquired once in post. We can argue about how many months sitting full-time in the Court of Appeal would expose the new judge to a sufficiently diverse range of appeals, and I acknowledge that some efforts are made to provide every new judge with some block Court of Appeal sitting. But in my view, there remains a mismatch of experience and expectation. And I wonder why that might be. Is it because crime has always been assumed by some to be easy enough to pick up? Is it because King's Bench judges are such exceptional lawyers, which I do not doubt, that we have trust in them picking it up? Is it because appointment criteria focus too heavily on the level of expertise in the candidate's chosen area of profession rather than their intended area of judging? Whatever the cause is, there is a mismatch. But is it a problem? Well, I've identified some potential problems. Are they really significant? An immediate challenge to my argument is that the problems cannot be so great in practice since the scheme has worked well for decades. My response is that the system is made to work by decisions of several key players behind the scenes. The President of the King's Bench Division and the Registrar of Criminal Appeals in particular. Despite the size of the division and the range of experience King's Bench judges bring with them, the President succeeds in matching every judge's experience to the particular murder to try. Likewise, the Registrar, acting as the gatekeeper of the entire appeal process, managing the thousands of applications, ensures that every King's Bench judge receives a fair allocation of permission applications under Section 31 and, more pertinently, avoids overburdening the inexperienced. It might also be argued that the current system plainly works because it produces some exceptional criminal judges from non-criminal backgrounds. In response, I endorse the celebration of the many High Court judges from non-criminal backgrounds who have excelled, and the many who've gone on to excel in the Court of Appeal. It's invidious to name names, but let me pick Sir Nigel Davis as an exemplar. Criminal judges and criminal lawyers amongst us like to think of such people as having finally achieved their true potential, of course. But they have achieved criminal brilliance. But such brilliance isn't necessarily demonstrated by all. That wasn't a very deliberate pause there, just to cause embarrassment amongst the High Court judges. I saw Nick Green looking nervous. Shortly put, my argument is that the current system of appointment or training does little to maximise the likelihood that people will excel. Some judges do so despite rather than because of the system. It works as well because I suspect no one complains. It burdens the King's Bench judge, though few might admit it. And it can generate discontent for practitioners, perhaps who have to accommodate and educate the inexperienced King's Bench judge. More fundamentally, perhaps, this claim that the system works is rather unambitious. It's short-sighted. It ignores the goal of an optimal system, to be satisfied by one which merely works. So what are some options for reform? I have persuaded you, I hope, that there is a problem to address, and I'm now going to consider some of the options, including, of course, radically the criminal division. The problem I've identified is that the judge may lack expertise and experience in criminal judging, so a predictable response is to offer more training of newly appointed criminal judges, newly appointed King's Bench judges trying crime. That would be highly desirable in any event, but I doubt whether the Judicial College can provide the optimal solution, at least as it currently operates and is funded. Currently, the criminal training for High Court judges is minimal, around 2 or 3 days, and in a chronically under-resourced system, is it realistic to expect such a substantial shift as might be necessary to meet my demands? I note that in the 2021 Judicial Attitude Survey, compiled by Professor Cheryl Thomas, the High Court judges, only 52% of them were satisfied with the time available for training. Secondly, and more importantly, while such excellent lawyers readily acquire knowledge of the criminal law through training, it's more time-consuming and demanding to attain the skills, which is what I'm arguing are of significance. They're best acquired over time and exposure to criminal trials. What I'm certainly not denying is the opportunity for creative use of judicial training, making it more integrated fully with the appointments process designed to deliver bespoke training to reflect the many different backgrounds of the King's Bench judges. Could appointments be contingent on training, including the acquisition of experience? That may have cost implications. It may be unattractive for applicants to think that they will be on a period of probation. But all of this is surely worthy of debate. It's related to a wider question about whether the Judicial College training provision, in my mind, is sufficiently geared to help judges progress in their career. A second solution may be the creation of a specialist subdivision within the King's Bench division. I mentioned earlier that we have Admiralty and planning and so on. Those are all recognised. Curiously, crime is not. The President currently authorises judges to sit in any number of those specialist courts subject to appropriate training, and judges hold multiple tickets. A criminal subdivision could be created with a ticketing system demanding criminal judicial experience. That could be coupled with more formal training and a transparent regime of allocation of appeals and cases. Some might say this sounds like the ideal solution to any of the problems that I've identified. It should certainly lead to greater efficiency and yet retain the flexibility of the deployment of King's Bench judges without the challenges of creating a new institution in the form of a division. I became aware quite early in researching the lecture that the solution would be a sound one, but I was also aware that as a lecture title, proposal to alter ticketing system in King's Bench division was probably not quite the crowd puller that I'd intended for my inaugural lecture. I wanted to entice you to a more provocative debate around a more radical solution, which may offer all of these benefits and more, a criminal division of the High Court. Now, I want to assess the relative merits of that criminal division by comparison with the more modest proposal for a specialist subdivision. And my proposal is that the new division would be staffed only by criminal specialist judges, and that would be to reflect and recognise the full distinctiveness of the decision-making required both in trial and appellate work, just as we do, of course, with family law. Given the problems I've identified, it might be quite a tall order for me to demonstrate that a division is needed. It's unlikely we can even agree on what that threshold might mean. But some assistance here might be provided by the literature relating to the specialisation of courts. And I commend in particular Brian Opskin's Current Legal Problems lecture from last year. Although this literature doesn't reveal a consensus, the wealth of the scholarship on specialised courts has exposed many of the factors worthy of consideration in assessing the relative merits of new specialist divisions. I put it no higher than that. It's difficult to assert that the specialisation scholarship provides a definitive framework, but it can enhance our debate. Specialisation, it's argued, generally promotes accuracy of outcomes, better quality judgments, greater consistency and efficiency, more authoritative statements of law, but it carries risks of narrow-minded isolation and insularity of the specialist judges, overconfidence, risks of clannishness with the specialist bar and the judges succumbing to faddishness, and a stagnation of the law for want of cross-fertilisation and so on. Alongside these costs and benefits, what the more recent scholarship has demonstrated, in particular Brian Opskin's lecture, is the need to consider the potential impacts on the core values within the justice system when we have specialised courts. What's the impact on the fairness of proceedings, promoting efficiency, confidence, as well as ensuring a fulfilled judiciary, a satisfied judiciary? Let's consider some of the benefits. Taking as a starting point the rectitude of decision-making, with a criminal division, in which every judge is possessed of expertise and experience, there would logically be reduced likelihood of error in the trial process and a consequent reduction in the number of appeals, thereby promoting finality. Such judges would also bring better prospects of quality decision-making in the Section 31 process and at trial, and more importantly, their contribution to the work of the Court of Appeal when sitting as a winger would be enhanced. They would be in a position to contribute more to the decision-making of that court. That should promote just outcomes, and those process gains should also promote stronger declaratory statements of the criminal law. There should also be efficiency gains in criminal trials. Wider benefits could flow from the greater flexibility of the deployment of the most senior judges in the Crown Courts, promoting their independence in the process. There should be fewer renewals on Section 31 as defence representatives accept the more likely accurate judgment of the expert criminal judge. On appeals, there'll be savings for the Criminal Appeal Office and the Registrar. Transparency should be enhanced in the allocation of appeals and trials. And all in all, the combination of those things should boost confidence in the accuracy of the decision-making from every perspective. The King's Bench judges will be more confident in their role, the Court of Appeal Office, counsel, and of course the defendant as participants would gain confidence in knowing that the judge is an experienced criminal judge. It's established more widely in empirical evidence that due process and diligence of the decision maker impact on the confidence of litigants. Thinking beyond the gains from the enhancement of existing practices more creatively, establishing a criminal division could offer opportunities for the reallocation of criminal-related work carried out by the administrative court. Such creativity might even extend to administrative courts constituted of 2 criminal high court specialists dealing with criminal matters, freeing up the overstretched Lords or Lady Justices of Appeal. A related problem, frequently and powerfully voiced by James Richardson, then the editor of Archbold. That's a practitioner text that is still used, I can reassure you. He condemned the fact that a criminal cause or matter related to an individual's liberty might be determined conclusively by a single High Court judge, including one with no criminal expertise. Guarantees of criminal expertise could prompt further creative rethinking as to the constitution and process of the criminal appeals system. 20 years or more now ago, Robin Auld suggested distinguishing between straightforward cases to be heard by 2 judges, while cases of more general public importance should remain the province of a full 3-judge Court of Appeal. Such radical schemes may be more palatable if the 2-judge court is constituted by 2 criminal division experts. I acknowledge that almost all of those benefits would be secured with the creation of a new subdivision of the King's Bench. They would promote justice, finality, efficiency. They could all be achieved. But there is a further dimension to the reform to consider, promoting a more satisfied judiciary. That might be best secured with the creation of a criminal division. Not only might it promote job satisfaction for those within the division who are confident in their experience and expertise, but it would create a clearer and more attainable career path for the most talented criminal judges. In 2021, in the Judicial Attitude Survey, only 56% of circuit judges felt there were good opportunities for career progression. Such judges would form a ready pool of candidates for the criminal division, possessed as they are of the precise qualification, expertise and experience. The very best cohort of the Crown Court judges have already been authorised to sit as wingers in the Court of Appeal. That's not to suggest that they should all be converted automatically to the High Court. I sensed some overexcitement from members of the Old Bailey. They don't get out very much, obviously. Judges in this pool are, from my anecdotal evidence at least, often deterred from even applying to the King's Bench. Several have confided in me over the years that they have been deterred or rejected for want of experience beyond crime. Unfortunately, I cannot substantiate this with evidence, as the Judicial Appointments Commission doesn't hold data on the proportions of applicants, interviewees or appointments made from the criminal circuit bench. The available talent of that judicial pool is, I suggest, underutilised, and the problem will intensify. Crown Court judges are appointed younger in life and yet able to serve longer, now until they're 75. And there is therefore a pool of individuals who are criminal experts who will, after perhaps a decade in post, face a further 20 more years in the same role with no realistic prospect of promotion. No wonder the Judicial Attitude Survey reveals such poor morale. The survey for 2021 revealed that of circuit judges, 37% reported that they were not satisfied or that job satisfaction could be better. 53% were not satisfied with or thought that career progression opportunities could be better. And when we compare to the High Court, 41% would consider leaving the judiciary over the next 5 years if that were a viable option. By comparison, the High Court judge, much more satisfied. Only 28% of them would consider that. Now, my task this evening has been to provoke a debate about whether a criminal division is needed. I don't have all the answers to the practicalities of the appointment. That would be a matter for the experts in judicial office, judicial appointments, and so on. But I would suggest that the division should not be exclusive to those who've sat as full-time circuit judges. Judges in the King's Bench division now and in the future should be permitted to be dual-ticketed, allowing them to sit in the criminal division as well, subject to acquiring sufficient expertise. Questions would need to be resolved about whether King's Bench division judges should be allowed to sit in the Court of Appeal criminal division. But subject to sufficient numbers in the criminal division itself, that might be unnecessary. Now, before anybody gets too carried away, there are some predictable objections, and I want to deal with these rather briefly. Many predictable objections. First of all, tradition. Well, some objections are no more than that. As Lord Devlin noted in 1979, there is no inclination in this jurisdiction to see that cases in a particular field are allotted to High Court judges with experience in that field. Despite the eminence of the source, perhaps we can dismiss this rather summarily, noting that it was closely allied to his view that no High Court judges needed any training on the matter of sentencing or allied matters. Thankfully, things have moved on. Life, law, judging, all more complex. Secondly, an argument that judges can just pick up crime. A clear illustration of this assumption noted at the outset that crime can be picked up by judges as they go along. Now, that view may have taken root at a time when King's Bench judges would have been likely in their early career at the bar to have had a broad common law practice, including some criminal trial work. But it was never the case that all High Court judges had such experience. Even for those who did, a breadth of historical experience as a junior advocate reveals little about expertise in criminal trial or appellate judgecraft decades later. And thirdly, this argument based on common law experience falters when so many of our King's Bench division judges are now appointed with illustrious public law backgrounds where the nature of litigation is very different, sometimes involving no witnesses whatsoever. There are some practical concerns as well. Recruitment. I doubt that that would be difficult for the reasons expressed above, but more of a concern on staffing, and one that cuts across possible gains in job satisfaction, is that it would lead to judges becoming insular and isolated. A criminal judicial mindset might take hold. A clannishness might develop, as Stephen Degumsky called it. I doubt that, given the breadth of the division that we're talking about. Criminal law is not as narrow as some of the types of specialist courts that have been debated and implemented in other jurisdictions. There would be costs, I accept. The total number of judges in the High Court would initially need to increase, at least until it became possible to reduce the number of appointments to the King's Bench division. There's also the legislation to consider, but although Section 5 of the Senior Courts Act 1981 stipulates that there shall be 3 divisions, by Section 7, another division can be created by ordering council on the recommendation of the heads of division and the Lord Chief Justice. Further practical objection, which I reject, is that a new division would provoke boundary disputes about whether or not something was truly criminal and fell within that division. Well, this is well-worn territory for those who are used to that expression, the criminal cause or matter. Let me turn then finally to some important challenges of policy. Does the creation of a criminal division represent a move towards over-specialisation in judging. The High Court poses interesting challenges here. Typically, arguments for specialisation are favoured, if at all, for first instance courts, with appellate courts remaining generalist. But of course, the High Court is multifunctioning. I'm already calling for more specialisation with training and at least a new subdivision. But is a new division itself a step too far? Caution has been expressed recently in characteristically lucid terms by Lord Justice Rabinder Singh. In his collection of essays, The Unity of Law, he would argue strongly, I anticipate, that the new division would damage the unity of law. One argument he advances is that the law is stronger because of the opportunities for cross-pollination of ideas from different branches of the law. I accept that must be true, but I question two things. First, whether the judge is typically the source of such cross-pollination, or whether it is more usually the ingenuity of counsel bringing to bear arguments from other branches of law. Secondly, if the judge is the cross-pollinator, how often that usefully happens in criminal cases below the Supreme Court or perhaps the Court of Appeal? How likely is it that a dispute in a murder trial is resolved because of a concept being transposed from another branch of law by the judge? That seems far less likely than the prospect of it being resolved satisfactorily because there's an expert criminal judge on the bench. Lord Justice Singh also rightly points to the fact that King's Bench judges are quick learners. They can be trained and they are, as I say, quick learners. Certainly they've all remained alert this evening. But that doesn't detract, that doesn't detract from the point made above, that currently the training is minimal and for financial reasons I doubt likely to increase. And secondly, that in this context, what can be acquired most readily by training is knowledge of the law. And yet what is needed, I've argued, is the exposure to experience. Recall that only 52% of High Court judges in the Judicial Attitude Survey were satisfied with the time available for their training. A third argument advanced by Lord Justice Singh is that the King's Bench judges should already be seen not as generalists but as versatile specialists. Points of law are points of law, he observes, capable of being resolved by any good judge. Well, in response, first I would repeat that the decisions made by the King's Bench judges in trying murders and on Section 31 applications bear many of the characteristics which scholars have suggested merit specialisation. The decisions can involve technicality, complexity, and yet be highly discretionary. The decisions relate to a single cohesive interconnected subject matter, and the decision-making is frequently repetitive in type, requiring consistency. Secondly, I would ask, does generalism in this context maximise the values promoted by efficient and accurate decision-making that would be likely to follow with a specialist judge? Thirdly, I'd question whether newly appointed King's Bench judges, at least, are really versatile specialist judges, or rather specialist lawyers, which we hope will evolve into versatile judges. And for me, this wider question about how specialist in discipline we want our High Courts to be and our High Court judges to be prompts the response, well, it depends on how distinctive the tasks are they are being required to perform. And that brings me back to where I began. Is criminal judging distinctive enough to be treated differently? Whatever your view of a new division, and I accept it's wholly unlikely to occur, I hope I have persuaded you that the systems of judicial appointments, judicial training, and the institutions, the senior judiciary, the MOJ, and so on, should not be adopting approaches to recruitment and deployment of judges that reinforce any assumption that crime is easy. Thank you very much.
David, thank you for such a careful, considered and thought-provoking lecture. Despite being controversial, I didn't hear anyone booing. So perhaps you've won them over.
I'm not going to ask for a vote.
the formal part now. On behalf of the Provost, I am delighted to formally inaugurate you, David Ormerod, as Professor of Criminal Justice in the Faculty of Laws at University College London. Many congratulations.
Thank you. Thank you. Thank you very much.
And so for those of you in the room, we have some celebratory drinks on the first floor. For those of you at home, I encourage you to raise a glass to Professor Ormerod. Thank you for joining us this evening.